Okay, so hello everybody, good morning and welcome to the EduphoreIAS, the live Hindu analysis class. Today the date is 21st of October and we are starting with the today's Hindu. So before we start our discussion, first of all, let us have a look at this question. First question is, by chance this has been, no, this answer is already given. So two-state solution in news is in the context of which the following. So of course you all know Israel-Palestine ongoing conflict, the war between Israel and Hamas. Second question was, given India's historically lower emissions, economic growth has taken precedence over climate concerns, but such an approach evades concerns of climate justice, such as its effect on inequality. We need to discuss this. 250 words for a 50-marker question. So yesterday on this editorial page, the lead article that we discussed, that was the shape of climate justice in a warming India. Fine. So therefore, this question is based on this article only. Fine. So again, following the same structure of answer writing, that is intro, body, and conclusion. Fine. We'll be first of all introducing our answer, just 4 to 5 lines. So you can say that the G20 summit that was held in Delhi agreed on tripling renewable energy capacity and a voluntary doubling the rate of energy efficiency improvement by 2030. However, this Delhi declaration on the climate question did not find consensus on the most contentious issue, which is the root cause of climate crisis, that is of phasing out of fossil fuels. Fine. So that should be your introduction for your answer. Okay. Next, coming to the body part of your answer. So of course, since the question is of 15 markers, so you can have here given the 3 major headings, and therefore under 3 major heads you can make 3 points for, well, find each 3 major heads. First is inequality matrix. Find this would be a major head of your body, first major heading, and under this you can mention briefly 3 to 4 points. Then comes the greening development. We have already discussed all of this yesterday, and therefore greening development, under this also you need to mention 4 points briefly. Then you have greening federalism. Even under this you need to mention 2, 3 or 4 points. Fine. And finally, in conclusion, you can say that somewhat we must, you can say, delve into the intricate interactions between the fiscal federalism and climate mitigation to understand how policy alignment and cooperation can be achieved across the different levels of government, taking into account or considering the sustainable development path ahead. Right? So this is how you can conclude your answer. That's it as far as yesterday's questions are concerned. Let us paper. So here we have the first or the front page. This is the front page. So Israel says it won't control Gaza civilians post-war. Okay, it will be having no control. It will not control Gaza civilians post-war. Fine. Say. Okay, did not violate diplomatic norms, India tells Canada. MEA issues a statement after Canada hits out at India for seeking reduction in number of diplomats. It says the move was necessitated by Canada's continued interference in the country's internal affairs. ठीक है, कनाडा एंड इंडिया के बीच में जो काफ़ी टाइम से चल रहा है पोस्ट नीजर मर्डर एंड ऑल, तो अभी ये खत्म होता हुआ नहीं दिख रहा है हमें. एंड इसी के कॉन्टेक्स्ट में कहा है इंडिया ने कनाडा को कि डू नॉट वायलेट, और इंडिया ने ये कहा कनाडा को दैट वी डिड नॉट वायलेट डिप्लोमेटिक नॉर्म्स, दैट इज वियना कन्वेंशन related to diplomatic norms or treatment, while India asked the 41 of the Canadian diplomats to be recalled. Right? This is related to this only, the repatriation repatriated, 41 Canadian diplomats to be repatriated. Fine. One. Yeah, has taken this on. Of course, and this time, government delays disturbs judicial seniority, Supreme Court, in appointment of what? Of judges this courts. PM flags of country's first regional rapid transit system, Namo Bharat, that is regional rapid transit system. 82-kilometer Delhi Ghaziabad Meerut corridor is scheduled to be functional by 20. Fine. Just take minutes from Delhi. With the design speed of 180 km per hour, it is a regional development initiative. Fine. So highest speed is 180 km per hour. You can see. Tribes can challenge March 27 order, High Court of Manipur. Further, OTT platforms, government reach jail, smoking warnings. Okay. Further, Kerala government firm halts fresh order style forms. Okay. Kannur-based company says it's stand until the conflict in Hamas ends. So here comes the states page, and states page you see more or less the politics only. Eradicate manual scavenging, SC tells central states. तो मैनुअल स्कैवेंजिंग आज भी प्रैक्टिस में है एंड इसको एराडिकेट करने की बात की है. Health center states. Okay. And we have here one of the acts called Manual Scavengers and Construction of Dry Latrines Prohibition Act 1983 and the Prohibition of Employment as Manual Scavengers and Rehabilitation 13. The top court itself had reinforced the prohibition and directed the traditional and otherwise engaged in the practice. What Manual Scavengers and their Rehabilitation Act. Alongside that, we have Manual Scavengers and Construction of Dry Latrines Prohibition Act 1983 as well. So there are two acts dealing with this, but at present, at this moment, we have legal this section for this scavengers as far as this one. Punjab government to move Supreme Court over bills, House sessions curtailed. Okay, so it been deadlock going on in Governor of Punjab and Government of Punjab. Okay. All clear for okay. New Governor of Odisha, Raghubar Das, former Chief of Jharkhand. Fine. Experts to look into Tista Stage 3 dam breach. सिक्किम में हुआ था जो this glacial lake outburst. Third. Fine. Again, here you have politics. Okay. Forcing children to recite any prayer against free thought, said by High Court of Kerala. Okay. Let's pay. that important. And again, we have a states page. Can you see politics? Lots of politics here. You can see here Mehrauli Park की बात हो रही है. Just get facelift as Delhi digs deeper into history. Mehrauli Architecture Archaeological Park. Next to Qutub Minar, you can see हमारे लिए historical aspects important हो सकते. Next to spread over 200 acres, Mehrauli National Park. Mehrauli Archaeological Park is adjacent to the Qutub Minar, a UNESCO World Heritage Site. Okay. And it is home to somewhat 55 historical structures built by various empires, including the Khiljis, Tughlaqs, Lodhis, Mughals, and the British. Many. So Delhi Sultanate was to British. All these empires are here. These include the Jamli Kamli Mosque. So you can say there are different places here. That's all what is important. Here we have editorial page, and from editorial page there are articles. One is smaller one, that is the lead one. These are important. First is frosty ties between India and Canada. So ordinary people will suffer as India and Canada cut down visa services. So India and Canada are headed for an even frostier season in ties after the Ministry of External Affairs latest move to pare down the number of Canadian diplomats in India from 62 to 21, recall of 41, while New Delhi had made its demand to equalize the numbers in the missions non last month. In the fiery aftermath of the Trudeau government's allegations that India had a role in Canadian Pakistani activities, matters were thought to have down. Fine. It had even been hoped that quid diplomacy was at work to repair ties. However, Canada continues to hold without proffering any further proof that India must cooperate in its investigation against unnamed individuals, while India is standing by measures. Fine. So देख सकते हो कि दोनों ही खड़े हैं, तो खास यहाँ से निकलता हुआ नजर नहीं आ रहा है. Last month, after a tit-for-tat expulsion of their respective diplomats from agencies, the Modi government suspended visas for all Canadians and downsizing of Canadian diplomatic strength as well. This week, India issued an ultimatum for the removal of 2/3 of those numbers with a deadline of October 31st, after which India would unilaterally withdraw diplomatic immunity. 31st October तक 41 of the diplomats हैं Canada के, उनको वापस लेना होगा, repatriation होगी, otherwise India would be in position to take unilateral decision. As a result, Canada's foreign ministry flew out 41 of its diplomats and their families, calling India's demand a violation of international law, including the Vienna Convention. Vienna, Austria, capital of Austria. So MEA has retorted that the convention's article 11.1 does authorize India to require that the size of the mission to be kept within limits. ठीक है, 62 लोग यहाँ पे क्या कर रहे हैं हमारे डिप्लोमेट कनाडा में, डाउन साइजिंग जरूरी है, let us equalize the numbers. Canada has also conveyed that with the staffing shortages now, consulate in-person visa services will no longer be provided. The Canadian Immigration Minister has added that India's move would not deter Canada's process. देख सकते हो कनाडा भी दोनों साइड से ही टिट फॉर टैट चल रही है, कोई भी पे वाइज पोजीशन नहीं है. The developments indicate that if there had been any diplomatic effort to diffuse past, they have been fruitless. Apart from Modi, Trudeau, and National Security Advisor meetings that had discussed the case, External Affairs Minister S. Jaishankar ji had reportedly met Canadian Foreign Minister in the US on the sidelines of the General Assembly. None of those appears to have turned the trajectory of events. Attempted by Canada's Five Eyes allies to mediate have not worked either. Five Eyes alliance क्या है, ये हम already कर चुके हैं. Five Eyes are UK, US, Canada, Australia, and New Zealand. So these are the Five Eyes intelligence alliance of these 5 countries. Intelligence sharing होती है इनके बीच में आपस में, highly classified intelligence. While the allies have supported Canada's claims, they have also shored up their ties with India, with possible visits by the British, US, and Australian leaders. that will assure New Delhi. With diplomatic options exhausted for now, it is hoped a period of reflection will bring fresh counsel on how to break the logjam. Till then, students, tourists and business persons will suffer. Of course, जो ordinary citizens हैं, जो भी एक देश से दूसरे जाते हैं, जो कनाडा जाएंगे, इंडियन से इंडियन कैनेडियंस इंडियन आएंगे, तो आमतौर पर दिक्कत उनको रहेगी, फाइन, बिकॉज ऑफ द वीजा इश्यूज, non issuance of visas in person, sorting of this Canadian. So not just a case about improving investigation. This article is little bit technical, little bit important. They will be having a different case laws here, fine, जो कि हमारी पॉलिटी के लिए खास करके इम्पोर्टेंट हो जाता है. यहाँ इम्पोर्टेंट केसेस हैं. कमेटी, मालीमत कमेटी की हम यहाँ बात करेंगे, लॉ कमीशन की बात करेंगे, कास्टिंग कमेटी की कास्टिंग की जजमेंट रही है उनके बात करेंगे. हाउ द क्रक्स ऑफ द आर्टिकल इज that there need to be a separate, there need to have separation between the investigation wing of a police and the laws and this order wing of a police, right? This whole article is devoted to this thing. The Supreme Court of India recently in Rajesh versus and another versus the state of Madhya Pradesh, while setting aside the conviction of 3 accused persons alleged to have been involved in murder and related offences, emphasized the need to devise a consistent and dependable code of investigation so that the guilty do not walk free on technicalities. कई बार आप देखते हो कि majority of the cases, even at the level of CBI, एविडेंस ना होने की वजह से, पुख्ता एविडेंस ना होने की वजह से, जो भी क्रिमिनल्स हैं, जो भी लोग इन्वॉल्व होते हैं मर्डर्स में एंड ऑल, कहीं ना कहीं वो आफ्टर सम टाइम को बरी कर दिया जाता है. So all happens because of the non-existence of proved this investigation report or evidence. ठीक है, सुप्रीम कोर्ट ने कहा है कि इन चीज़ों ऐसी दिक्कतें ना आए जहाँ पे कि हमें गिल्टी जो है उसको that won't be able to walk free on technicalities or the evidence, lack of evidences. के लिए हमें consistent and dependable code of investigation को बनाने की जरूरत है. The court not only pointed out some illegalities in the investigation but also echoed the comments of Justice Malimath Committee on Reforms of the Criminal Justice System and the observation of the Law Commission of India in its report number 2929. So here is a reality check on both these observations. First, Malimath Committee recommendations and second, the Law Commission report. Fine. तो इन दोनों के बारे में हम वाले हैं. तो वेरिड इंटरप्रिटेशन, एक मेजर पिटफॉल जो है पॉइंटेड आउट बाय द कोर्ट रिलेट्स टू द सेक्शन 27 ऑफ द इंडियन एविडेंस एक्ट. दिस इज रिलेटेड टू द इंटरप्रिटेशन ऑफ द सेक्शन 27 of the Indian Evidence Act, the IEA, right, which lays down conditions of the admissibility of any fact discovered in consequence of information received from a person accused of any offense in the custody of a police. The court held that the person could not be said to be in police custody till formally arrested. एक बात है कि जब तक फॉर्मली आप किसी को अरेस्ट नहीं कर लेते तब तक आप उसको पुलिस कस्टडी में नहीं कहा जा सकता कि वो पुलिस कस्टडी में है. ठीक है, as he did not figure as an accused person in the FIR फर्स्ट इंफॉर्मेशन रिपोर्ट, कि जब तक आपने उसको एक क्रिमिनल या एक्यूज नहीं बनाया है FIR में तब तक आप उसको अरेस्ट नहीं कर सकते. ठीक है, या उसको ये नहीं कह सकते कि he is or she is under police custody and was not accused of any offense till his arrest. So this assumption does not appear to be a correct proposition of law. What the writer is saying कि ये assumption जो है कोर्ट की, ये कहीं ना कहीं it doesn't appear to be a correct proposition of the law. Again एक केस की बात कर रहे हैं. In मान सिंह 1959, the court held that the word custody does not necessarily mean detention or confinement. Rather, the submission to custody by any action or words is also custody within the meaning of this section. तो कहीं ना कहीं आप ये देख सकते हो कि जो मान सिंह की जजमेंट थी कोर्ट की, जो अभी की जजमेंट है, जो ऊपर वाले पैराग्राफ में हमें किया, दोनों ही आपस में कन्फ्लिक्टिंग से है। जो कोर्ट ने यहाँ कहा वो यहाँ पे नहीं कह रही। Even indirect control over the movement of a suspects by the police has been held to constitute police custody. In Chote Lal versus State of UP in 1954 and many other similar cases, the court also held that an accused is in police custody within meaning of the section when he is under surveillance of the police and cannot break away from the company. अगर कोई एक्यूज जो है वो पुलिस कस्टडी में है विद इन द मीनिंग ऑफ सेक्शन 227, so of course he is under surveillance of the police and he cannot run away, cannot break away from the company of the police. Another case, that is the Supreme Court in the state of UP versus Deman Upadhyay 1960 held that the expression accused of any offense is descriptive of the person against whom evidence relating to information alleged to be given by him can be by this section. In another case, MD Dastagiri versus State 1960, the top court held that it is not necessary that when a statement is made by a person, he should be an accused, that it is enough if he is an accused person when it is sought to be proven in court. स्टेटमेंट जरूरी नहीं मेड करना, अगर कोर्ट में प्रूव हो गया कि वो गिल्टी है तो गिल्टी है, सीधी सी बात है. So different, you can say, the interpretation of the court has been given with the passage of time. You see initially 1950 से लेकर के अभी तक की जो इंटरप्रिटेशन है कोर्ट की 7 ऑफ द इंडियन एविडेंस एक्ट वो डिफरेंट रही है. ठीक है, डिफरेंट टाइम. यस, so therefore custody under section 27 of the Indian Evidence Act does not necessarily mean formal arrest by the police. ठीक है. Similarly, the court laid too much emphasis on seeking compliance under section 100 clause 4 and section 100 clause 5 of the Code of Criminal Procedure CRPC relating to presence of independent witness during search and seizure of a place in the discovery memos such as discovery and seizure of the body of deceased and his clothes and the weapon of murder. की यहाँ पे जब इस तरह की 105 and 104 clause 4 and 5 अंडर कोड ऑफ क्रिमिनल प्रोसीजर दैट इज सीआरपीसी के अंडर अगर सर्च एंड सीजर चल रही है पुलिस के द्वारा, तो उस टाइम पे देयर इज नीड टू हैव अ पर्सन और द प्रेजेंस ऑफ इंडिपेंडेंट विटनेस. अनदर केस इज इन मुशीर खान एट बादशाह खान एंड अनदर वर्सेस स्टेट ऑफ एमपी 2010. the court held that if the discovery under section 27 of Indian Evidence Act is otherwise reliable, its evidentiary value is not diluted just by reason of non-compliance of section 4 or section 5 of the CRPC. तो ऊपर ये कहा कि एक इंडिपेंडेंट विटनेस होना चाहिए. यहाँ पे क्या कह रही है कोर्ट कि अगर सेक्शन 27 जो है इंडियन एविडेंस एक्ट की इज अदरवाइज रिलायबल इफ एविडेंटरी वैल्यू इज नॉट डायलूटेड जस्ट बाय रीजन ऑफ नॉन कंप्लायंस, कि अगर एविडेंटरी वैल्यू जो एविडेंस है उसको डायलूट ना किया हो सिर्फ इतना करने से कि अगर कंप्लायंस नहीं हुई है रही है पुलिस की विद दिस टू सेक्शंस 104 and 105 of the CRPC, the evidence cannot be diluted or rejected. So the reason is that section 100 deals with the processes initiated to compel the production of things search, whereas the very basis of facts deposed by an accused in custody is voluntary and pursuant to discovery taking place. तो दोनों में डिफरेंस है कि एक बंदा जो कस्टडी में है he is voluntarily and pursuant to discovery, he can voluntarily give certain evidences, but search and seizure के केस में the police compels the other party to use the evidences. So there is a difference in the two. Another case, and that is similar views were expressed by the top court in the state NCT of Delhi versus Sunil 2021 also. In fact, such panchnamas are prepared by the police as a rule of caution and not in compliance of any mandatory provision of law. ठीक है, सेपरेशन ऑफ इन्वेस्टिगेशन की अभी यहाँ पे बात कर रहे हैं कि कहीं ना कहीं by highlighting excerpts from the Justice Malimath Committee report and the Law Commissioner report, the court expressed regret that the standard of police investigation is still poor and that the principal causes of a low rate of conviction. बिल्कुल ठीक बात है. हमारे यहाँ अगर पुलिस सीबीआई तक की यहाँ की इन्वेस्टिगेशन जो है वो कोर्ट इनवैलिडेट कर देती है बिकॉज ऑफ पता नहीं जानबूझ के यहाँ एविडेंसेस नहीं कलेक्ट किए जाते हैं, एविडेंसेस होते ही नहीं है. सच में सीबीआई 2 से 3 साल 4 साल लगाती है केस को इन्वेस्टिगेट करने में 4 साल 5 साल के बाद कोर्ट देती है कि भाई आपके पास एविडेंस ही नहीं है, दैट्स वाई जो भी गिल्टी हैं इन्वॉल्व थे लोग उनको हम बरी करते हैं। So it includes inept and unscientific investigation by the police. There is no doubt that the quality of investigation needs to improve and that the police should use the best available scientific investigation. However, the court also needs to review the reforms that have taken place in the police in pursuance of the recommendations made by various commissions and committees in the past. On the subject of investigation, the Justice Malimath Committee had recommended that the investigation wing should be separate from that of the law and order wing. Okay? तो इसको चेक करने की जरूरत है कोर्ट को कि कितने स्टेट्स ने ऐसा किया है कि जस्टिस मैलिमथ कमेटी के रिकमेंडेशन के अकॉर्डिंग कितने स्टेट्स ने अपनी पुलिस विंग में जो इन्वेस्टिगेशन विंग है उसको सेपरेट रखा है किससे, लॉ एंड ऑर्डर मेंटेनेंस। ठीक है, तो कहीं ना कहीं कोर्ट को ये भी देखने की जरूरत है। उसके बाद लॉ कमीशन रिपोर्ट की बात की थी हमने फर्स्ट पैराग्राफ में 239 तरह से नंबरिंग होती है। It was submitted on the directions of the court in Virendra Kumar Ohri versus Union of India and others pertain to such regard to expeditious investigation and trial of criminal case against influential public personality. कि इसमें भी जो रिपोर्ट है 2009 सबमिट की गई थी ऑन द डायरेक्शन ऑफ द कोर्ट इन वीरेंद्र कुमार ओहरी वर्सेस यूनियन ऑफ इंडिया केस. With regard to investigation, the law commission observed that the police stations are understaffed, sufficient priority is not given for the investigation of crime, and that there is no periodic exercise to upgrade the skills of investigation. So all of these, you can say the negative sides or the, whatever this issues or the problems we are having in policing this system, you can say Indian police system or related to the investigation wing of the police. This is what pointed out by this law commission of 239. तो रिमेंबर इस आर्टिकल से ये दोनों चीजें इंपॉर्टेंट है। जस्टिस मैलिमथ कमेटी की जो रिकमेंडेशंस है दैट वाज कमिटी वाज रिलेटेड टू द रिफॉर्म्स ऑफ द सिस्टम प्लस द लॉ कमीशन रिपोर्ट नंबर 239। ठीक है, क्या इन दोनों ने कहा है वो हमारे लिए काफी इंपॉर्टेंट है टू द इंडियन पुलिस रिफॉर्म्स। ओनली मेंशन्ड इन इट्स 154th रिपोर्ट, एक और रिपोर्ट है, बट ऑल्सो रिट्रेटेड द डायरेक्शन ऑफ द टॉप कोर्ट गिवन इन प्रकाश सिंह others versus Union of India and others in 2006. प्रकाश सिंह एक काफी फेमस जजमेंट है फॉर द प्रकाश सिंह जी जो डीजीपी थे, देख सकते हो, फॉर्मर डायरेक्टर जनरल ऑफ पुलिस उत्तर प्रदेश, फॉर्मर डीजीपी असम, फॉर्मर डायरेक्टर जनरल ऑफ बॉर्डर सिक्योरिटी फोर्स बीएसएफ। तो इन्होंने एक प्ली डाली थी कोर्ट में, सुप्रीम कोर्ट में, रिलेटेड टू द रिफॉर्म्स इन द इंडियन पुलिस सिस्टम। कहीं ना कहीं कि उसमें कोर्ट ने 7 पॉइंट ऑफ डायरेक्शंस दिए थे, उसमें से कितनों पे एक स्टेट्स ने अमल किया नहीं किया, दैट इज अगेन अ मैटर ऑफ इन्वेस्टिगेशन। So out of a total 7 directives by the court, 1 pertain to a separation of investigation from law and order to ensure quicker investigation, better expertise and improved rapport with the people. This separation was to be taken up first in towns and urban areas with a population of 10 lakh and more and gradually extended to the towns. First 7 डायरेक्टिव में से एक इंपॉर्टेंट जो डायरेक्टिव थी कि जो लॉ एंड ऑर्डर विंग है पुलिस की, स्टेट लेवल पे बात कर रहे हैं, और इन्वेस्टिगेशन विंग जो है वो इन दोनों को सेपरेट किया जाए। ठीक है, तो स्टेट रिस्पॉन्सेज आप देख सकते हो, समिंग ऑफ द रिस्पॉन्सेज ऑफ द स्टेट गवर्नमेंट्स, मिस्टर सिंह, दैट इज प्रकाश सिंह, writes in his book The Struggle for Police Reforms in India 2022 that 17 states have taken measures to separate the investigative and law and order functions of police. The remaining states are not opposed to this directive but have yet to initiate. But when it comes to overall compliance of the 7 directives, 9 states fell under the good and satisfactory category and 20 states in the average and poor category. However, going into the details of responses, one could decipher that the most states have either made some provision in their state police act or have issued administrative orders only. Fine. तो ये सारे इश्यूज हैं, आप देख सकते हो कि किसी भी स्टेट ने बहुत अच्छा काम नहीं किया। फाइन। So separate staff for investigation has not been provided for. the book says about Madhya Pradesh. It's difficult to believe that a code of investigation does not exist in the states. These are also revised from time to time, and the Supreme Court's instruction included wherever required. However, the investigating officers are not only inadequate in number but are also unable to upgrade their skills because there is a shortage of officers. ठीक है, सो अल्टीमेटली सारी क्रक्स क्या है कि हमारे यहाँ शॉर्टेज जो है किसकी, ऑफिसर्स की है, स्किल्स जो है उनकी अपग्रेड नहीं होती टाइम टू टाइम, एंड ऑफ कोर्स इनएडिक्वेट नंबर है ज़्यादा है. Only symptomatic treatment of police reforms by having some provisions in the rules and regulation will not help much. Therefore, the need of hour is that the Supreme Court needs to step forward and ask every state and union territory to report compliance of its directives on investigation and other issues in letter and spirit. Similarly, there must be consistency in its rulings unless earlier judgments are clearly overruled by or overruled for cogent reasons. Okay, a very good masterpiece article, you can say, especially related to giving us an idea about the criminal justice in India and where exactly the issues matter, especially with police, fine, by the state police. So important है, यहाँ पे सारी चीजें बात की गई है. You can use this fodder in your GS2 polity section, polity and governance. Then what else important? Miscellaneous thing. Manipur High Court permits tribes to challenge March 27 order. Order क्या था? Order actually was this order has directed state government to send recommendation on ST status Meiteis. Okay? Meiteis community जो है, हमने 2-3 दिन पहले भी देखा था कि 2 बार इस Meiteis community को जो सजेस्ट किया गया था कि इसको ST की स्टेटस है उसको रिजेक्ट कर दिया गया था, बट कोर्ट ने ये कहा था कि स्टेट गवर्नमेंट कैन सेंड रिकमेंडेशन with this. So this became the trigger for the ethnic violence that began on May 3. Fine. Review plea by Meitei body pending in the court. Army held over 400 meetings with the society groups. Rifles and army. Proof किया जाए. Okay, what else important? What else more as part of Meri Mati Mera Desh, Railways plans expense. Further, you have here lots of politics only. Again, you have politics only. तो हमारे प्राइम मिनिस्टर की जो मन की बात है जो आप संडे देखते हो, सो नाउ पब्लिश्ड इन द फॉर्म ऑफ बुक, देख सकते हो. जो एक इम्पॉर्टेंट है चीज़ है दैट इज रिकग्निशन फॉर Dhordo shows India's tourism potential because Dhordo in Gujarat made it to the United Nations World Tourism Organization's best villages list the year 2023. So आपको ये पता होना चाहिए, पहले एक तेलंगाना की विलेज आया था उधर पोचमपल्ली करके ऐसा कुछ, तो ये पता होना चाहिए आपको. गगनयान मिशन, इसरो इज सेट फॉर फर्स्ट टेस्ट फ्लाइट टुडे. ठीक है, गगनयान मिशन जो हम लॉन्च करने वाले हैं उसके लिए कुछ इसरो जो है वो ट्रायल के लिए टेस्ट फ्लाइट करने वाली है, तो इसके लिए इसरो आज जो है सेट फॉर फर्स्ट टेस्ट फ्लाइट टुडे. द स्पेस एजेंसी विल कंडक्ट अ क्रू मॉड्यूल टेस्ट द पार्ट ऑफ इट्स प्रोग्राम which aims at sending humans into space beginning next year. One unmanned flight will कि रियल में लोगों को भेजने से पहले ह्यूमनॉइड के फॉर्म में एक अनमैन टेस्ट फ्लाइट जो है वो भेजी जाएगी। अगर ये मिशन रहता है तो हमारे लिए बड़ी अच्छी बात होगी इस डायरेक्शन में। आर्मी ऑफिशियल्स लेसन्स फ्रॉम इजराइल एंड यूक्रेन conflicts. Calcutta High Court says every female adolescent should charge. Court calls for decriminalization of consensual sexual acts involving adolescents above 16. कोर्ट ने ये भी कहा है कि जो भी 16 से अबव के हैं डिक्रिमिनलाइज किया जाए एक्ट्स। okay? मैटर्स फ्रॉम द वर्ल्ड पेज। सो वर्ल्ड पेज से हमारे लिए पाक चाइना साइंस 20 डेज विजिट। ओके, केयरटेकर प्राइम मिनिस्टर ऑफ पाकिस्तान, BRI जो ऑन द साइडलाइंस ऑफ BRI समिट, कंट्रीज के हेड्स हैं वो चाइना पहुंच। नो पॉलिटिकल स्ट्रिंग्स इन आवर सपोर्ट, जिनपिंग प्रेसिडेंट ऑफ चाइना हैज सेड श्रीलंका। हमारी जो सपोर्ट है वो कोई पॉलिटिकल या कोई ऑब्जेक्टिव नहीं, अच्छी बात है। अगर ओके, बिजनेस नाउ। ग्लोबल अनसर्टेनिटीज हैव राइजन ओवर द पास्ट फोर्टनाइट। बात है अक्रॉस द अगर आप देख सकते हो जो ये हमास वॉर चल रही है, रशिया यूक्रेन पहले से ही चल रही है, तो ग्लोबल अनसर्टेनिटीज तो सारे हैं। तो stock exchanges and financial institutions must be the first line of defense against rising risk, said by RBI governor, cautioning that interest rates will remain high in the future. Household consumption propping up economy. So कहीं ना कहीं this reflects कि जो डिमांड है वो इकोनॉमी में बढ़ रही है, जनरेट हो रही है, इसलिए हाउसहोल्ड कंजम्पशन दैट इज एक्चुअली ड्राइविंग अप द इकोनॉमी। Malaysia eyes India to boost tourism via rustic homestays. Okay, so Malaysia is gearing up to sell rustic homestays for cities, women's groups, professionals, and families in India. Okay, in Bengaluru, Chennai, New Delhi, Mumbai, Kochi, and Amritsar to showcase the country's diverse rustic homestays under cluster showcase की करेंगी, so that कि जो टूरिज्म है इंडिया से, फोकस जो है इंडिया एंड चाइना पे है। Malaysia is currently able to attract only 50,000 foreign students. India and China will be its focus geographies to grow the sector. Okay, कि आए यहाँ पे रहें। OTT services, government reach uneasy compromise on smoking warnings. Warnings दिखाओ। Have this here. World Cup, all sports. That's it from the day. Fine. As far as today's Hindu analysis is concerned, that's it. Have for the day. If you have any query, anything in the comment section, till then, take care, keep revising Mondays in. Fine.